me. Listen.
Oh, no.
Let me tell you something. If you don't stop when I tell you to stop, I'm going to take you out of here. We're not getting into whether somebody has a license to practice law. You can't. Let's release the... Now, you're not getting another one. I'm just telling you.
I'm reserved right for judiciary fighting on the legitimacy of the court.
Before a single ruling is made, the tension in this courtroom is already boiling over. The judge knows exactly what kind of hearing this is about to become, a battle not just over retail fraud allegations but over control of the courtroom itself. The defendant is challenging procedure, questioning authority, and pushing every boundary of patience. What starts as a standard probable cause conference quickly transforms into a confrontation over legal representation, courtroom legitimacy, and whether this case will move forward at all. You can hear it in the judge's voice immediately. This is no routine appearance. One wrong answer, one more interruption, and the consequences are going to hit fast. And that warning comes sooner than anyone expects.
I did an extra 30 days,
Well, if you keep this up, you're gonna be here another 30 days. Do you want me to adjourn this case again?
No, I don't want to go. I'm really actually having to admit.
No.
To the fact that
We're not doing that. That's 00791 FY State of Michigan versus Timothy Dansby.
Yeah, people.
Standing in for the attorney of record, Van Donick, and appearing on behalf of Mr. Timothy Dansby, who states to my right. Mr. Dansby, can you please state your full name for the record?
Timothy Dansby.
All right, Mr. Dansby, we're back. Do you mind having Ms. Miller stand in for Mr. Gonick for today's hearing?
I love to the court, I still observe my wife. I mentioned all the previous hearings, but part of today's process has been going what's going to continue going what's going. I feel
Does that mean you don't mind her standing in?
one interpret.
Okay, you know what? I'm not going to play the game. That's a yes or no question.
I don't even.
Okay, do you want to adjourn it and see who it is? You have a right to have the counsel of record present if you want to be here instead of Miss Miller. And this is basically for a probable cause conference and the jury date on a retail fraud first degree. Well, we had adjourned it before for your lawyers to get video discovery. So do you mind her standing in or no? Okay, so you don't want a lawyer, sir? I'll release him if you don't want one. Nobody's going to force you to have a lawyer to help you. If you want to do it all yourself, do it. Do you want me to release the lawyers?
You know, thing for him soon right now.
Do you want a lawyer? Yes or no? It's a real easy question, sir. It don't take all day. Listen here. Okay, if you don't answer the question, I'm going to release the lawyers. If that's what, because you've been complaining the whole time about, I didn't ask for no state attorney. I don't want to, I don't know what it, whatever you going to do. No, I'm not doing anything. I didn't appoint the person in the first place. I didn't do it. Okay, so you don't want them? Is that what you're telling me? Do you want them? Yes or no?
All on the same.
Sir, listen, this is not going to be a matter of semantics. Do you want one or not? Because nobody's going to force a lawyer on you. I'll be happy to handle this case with you by yourself, doing whatever you can do to help yourself. If that's what you want.
I still ain't got my discovery, so.
So, do you want a lawyer?
I'm sorry, I'm still on the same thing. I think.
I don't even know what that is. Whatever your claim is, I don't know. Okay, let's release the lawyers. All right. Now, you're not getting another one. I'm just telling you.
I reserve the right for judiciary and judiciary finding on the legitimacy of the court.
You're not getting another lawyer, okay?
Boy, I said
I don't know what you can reserve what you want. I don't mind.
finding the other court and the legitimacy of the court as far as the defense argument.
Sir, whatever you want to do, you can do. But since you don't want a lawyer, I can't by law give you one. So
That was three Germans ago.
guess what? So
Lord have you given me the things that I need.
okay, sir, nobody can give you anything but a piece of paper. They can give you that. They could give you the police report. They cannot give you the videos because there's no way for you to watch them.
Make sure that the law library at the court, it will order that the law library at the court need to have a clerk or somebody to present the information for me to see the video. I don't know. Maybe you just don't want to make time.
Sir, I don't even know. I don't know anything about your law library wherever. All I know is these video files. They're files. They come on a computer.
So, the law library should somebody to be giving people at the law library a heads up to make it law.
Well, you know what? That's up to you to figure out how you're gonna get it.
I'll let the second circuit figure it out. Second circuit fix it. You know, probably judge, second court, Supreme Court, we can let them figure it out. I'm straight. Well, I ain't doing nothing.
Ready for me to take them.
Well, you can just you know.
Your Honor, would you like Mr. Donovan to file any sort of motion or
No,
hold forward or to have him withdraw?
no, I'm gonna write an order right now, releasing him.
Your Honor.
And so we will reset this, I guess. I don't know why we got him. We could actually bring him back out, and he could decide what he wants to do today.
I do know that he is wanting to have his preliminary examination. That is
Okay, well, let's set it for an exam then. How many witnesses, Mrs. Shockley?
All right, just me one.
All right. You want to wait for your order? You can.
Okay, thank you. One witness.
Right.
Yeah. One witness and one defendant that's going to make it way longer than it's supposed to be. So factor that in.
Court's available October 3rd at 10:30.
All right. So October 3rd at 10:30. Is the exam date. And could you ask Mr. Gonick to make sure he gets a discovery, what he has, over to this person?
I believe that paper discovery has already been given to him. I'll see if the court or if the jail will allow us to give any sort of drive or anything like that that encloses the videos.
This record, I would advise the court the discovery, the AV discovery in this matter is 99% police body worn camera, which has the defendant in it, and there's only one in-store video of the defendant walking past it. So,
Okay.
you know what?
Okay. Well, good. Just make sure he sees it. Just some of your best efforts on that. And people of the state of Michigan versus Timothy Dansby. Sir, what's your name? All right, Mr. Dansby. Good afternoon. Mr. Shockley, place your appearance on.
Track on behalf of the people.
All right, today is the date scheduled for a preliminary examination. This is on one count of retail fraud, first degree. People prepared to proceed.
Yes, Alex.
All right, any preliminary matters?
Did you Pursuant to the court rule, confirm that the defendant still wishes to represent himself, as this is a critical proceeding.
This is the first major turning point, and it is a dangerous one for the defendant. By refusing to give a clear answer about whether he wants legal counsel, he has pushed the judge to make the decision for him. Court-appointed lawyers are not something a defendant can casually reject and then demand back later. The judge makes that crystal clear. Once these lawyers are released, there may not be another chance. What makes this moment so intense is that the defendant seems focused on principle, challenging legitimacy and demanding discovery, while the court is focused on procedure. Those are two very different battles, and right here, by losing counsel, he may have just made the road ahead much harder than he realizes.
No, but do you still assume he did?
Yeah, it just has to
He's
be
been-
there.
He's just been asking all this time, would you still want to represent yourself? You've been telling us all this time, do you want to represent yourself?
I've been wanting to represent myself.
Okay, so you want to proceed today by yourself without a lawyer, right?
Not before I let it be known that I still never received my full discovery.
Well, what haven't you received, sir?
I haven't had a chance to go over the videotape because one of the witnesses in the videotape is I know that when I was speaking to him and was saying, letting him know that, look, man, put this stuff back on here because I'm choosing not to buy it here and I'm going someplace else. So it wasn't like I was trying to steal nothing when I told the guy this particular I wanted to make sure that he's be available to be questioned.
I don't know who he's going to call. See, this isn't a trial. So this is just your probable cause hearing. So the prosecutor has a very low threshold burden of proof. He doesn't have to put on every witness, he said. He doesn't necessarily have to use the video. He might. And if you say the video means something else, that creates a question of fact that would go to trial for the trier fact to resolve. And of course, you get an opportunity to question about the video in depth at trial.
Also, I'd like to mention the fact that, you know what I'm saying, that it's been a delay because I don't know who these people been coming up here. I've been telling the court that I've been wanting to represent myself.
Well, you've been representing yourself since the last time.
Well, I with them saying at the county jail, they said without the court allowing them to know that I was representing myself, there was certain information I couldn't get. They would not give me. Like the Michigan court rules of evidence. You know what I'm saying? For part of,
I've never heard of the court having to tell the jail you're representing yourself. I've never heard of that.
The new technology, they tell the law library you can go. But now you do everything over the computer.
Okay.
You got to leave a request. In order for them to fulfill your request, they have certain criteria that you got to show ahead of time.
Well, sir, I don't know anything about what the jail's criteria is.
And also, I'd ask, for a standby lawyer.
But they don't do that.
Well, from my understanding from previous experience,
What year was that?
From federal circuit court and from other courts.
Federal Circuit Court.
No, I know they have to be a circuit court. They have done.
This is the state system.
There has been opportunity to have standby lawyer for instances where they could confer certain information that the prosecutor might not want to give to me because he might feel he's better than me or something. Because he feels that my consultation might
Listen, Mr. Dansby. We can't.
he might allow me to say
No,
stuff.
of course you got. That's not true. You have a right to represent yourself and you do have a right to get discovery. But what you can't do is come in here on the day of the hearing claiming that, oh, now you want to stand by counsel. Okay, but I'm telling you.
I'm just saying, well, from my experience, it's always been standby counsel been set.
I don't know what your experience is. I just know what Michigan and I don't know when you got.
Well, information.
Okay, sir. The Michigan Indigent Defense Rules, they have a whole new program that's been started a few years ago. So we used to do standby counsel and anything like that. We used to do that all the time when the court was appointing. Now they have a whole system. They don't pay for that. They say if the defendant wants a lawyer, fine. But there's no, quote, standby lawyer in their view, so they don't pay for that. I didn't make that rule. The person,
I couldn't verify it if I wanted to without.
Well, the person that
without the people in the jail who's running the law library information able to send me the information that I need, because without them having their quote,
Okay, what information do,
their quote unquote,
sir, what information do you think you need just for a preliminary exam?
Your Honor,
No, I said for Michigan defense appointment.
So then you said it used to get stamped by counsel.
I said we did before that system was created.
Well, I want all the things to update on the system, you know?
Okay, but that has nothing to do with this.
Court rules of evidence.
Your Honor, I'm gonna, just so I can expedite this, and to satisfy the defendant, at the circuit court level, the circuit court has the budget and the ability and the staff to appoint a statement on counsel once he gets up there. And once we finish this hearing, he may be up there, and he can make that request then, and I'm sure the circuit court will have no problem immediately assigning him an attorney to advise him as he represents himself. As far as the people are concerned, the court rules been complied with. He's freely and voluntarily relinquish his right to an attorney. May I call my first
So
witness?
the court, so yeah, I like to also state that I still haven't received my discovery, and my date was postponed because of some guy who.
This is where the legal reality collides with the defendant's expectations. He believes the missing video details could prove his innocence, that he intended to pay, that there was no theft, that context changes everything. But the judge is explaining something critical. This is not the trial. This is only a preliminary examination where the prosecution's burden is incredibly low. They do not have to prove guilt beyond a reasonable doubt. They only need enough evidence to show probable cause that a crime may have occurred. That difference is massive. The defendant is arguing for acquittal-level proof while the court is only deciding whether the case should move forward. In that mismatch, frustration grows and the courtroom pressure keeps rising.
Say he was my attorney. I did an extra 30 days, the extra 30 days.
Well, if you keep this up,
That's my attorney.
you're
Why
gonna be here another 30 days. Do you want me to adjourn this case again?
No, I don't want to talk. I'm really actually having dismissed.
No,
The simple fact that
we're not doing that.
or ask for a personal bond, because I've been had my cases adjourned on other people's.
Sir, you the one that asked for new lawyers or no lawyer.
Ask for any new lawyer, because I never accepted the first. I have never signed for an appointment of an attorney from the very beginning, even at
Okay, sir. Well, we're gonna proceed with your preliminary examination without a lawyer. So you should be happy today that you don't have one. And then when you get to the circuit court, ask them to give you a lawyer. That's he just said they have a budget for that.
Have them give me my discovery.
What discovery don't you have? What tape?
Your Honor, I'm gonna play the tape for him today anyways. There's no right to it. There's not even a right to discovery before a preliminary exam, technically underneath the court rule. I mean, we deal with this all the time. So this is just an intermediate proceeding. It's not gonna affect anything. As you know, attorneys don't even ask questions a lot of times during preliminary exams because it creates a question of that.
But they certainly don't call. They might ask questions, but they don't call witnesses.
You know, not in all situations. With all the preliminary exams.
Okay. Have a seat, sir, unless you want to stand up for the whole hearing. Call your first witness.
People go to the same Robert Stanley.
Okay, Mr. Shockley, are you ready?
I'm ready.
Okay. Raise your right hand. Do solemnly swear or affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth.
Yes, sir.
All right, thank you. Have a seat. And Mr. Shockley, whenever you're ready.
Yeah. Sir, when you are ready, will you please state and spell your name for the record? Who is your employer?
Meyer,
What is your job title with Meyer?
Asset Protection Team Lead.
Asset Protection Team Lead?
Yes, sir.
And how long have you been employed in that capacity by Meyer?
Since January of 2025.
Did you receive any specialized training to have that title or that role?
Yes.
And what do you do? What kind of training?
So it's a multitude. So over years, Wicklander certified, and then different courses in asset protection and policy related.
Were you employed in that capacity on July 26, 2025, around 5:30 p.m.?
Yes, sir.
And so, do you work at a specific Meyer store or multiple stores?
I'm assigned to the one in Southfield.
Is that located at 28800 Telegraph Road,
Yes.
City of Southfield,
Yes.
County of Oakland?
Yes.
On that date, around that time, did you identify a retail theft in progress?
Yes.
And how did you identify that?
In this particular case, it was just rapid selections of similar merchandise.
What do you mean rapid selections?
So one of the indicators of theft is grabbing merchandise without looking at price, or without appearing to look at price, size, that kind of thing.
And how did you see this occurring?
On the floor.
Were you physically on the floor, or were you watching cameras?
Sorry, I was physically on the floor.
Did you follow this individual
I did.
as he was selecting items?
Correct.
Do you see that individual you were following presently in the courtroom?
I do.
Will you please point and identify an article of clothing he is wearing?
It's over to my left, and he's wearing like a blue shirt with a white t-shirt.
Your Honor, may the record reflect the proper identification of the defendant?
Yes, so ordered.
Upon following this individual, did at one point he come to the point of sale?
He did.
Was that before, at any point did he try to walk out before coming to those points of sale?
No.
Did he have a cart, or was he concealing these items on his person?
It was a cart.
Was that cart full?
Yes.
Upon him going to the point of sale, what did you, just so we put, you were at the point of sale when he got there.
I was, yes.
And what did you see him do at that point?
He went up to a cashier and myself and asked where the bathroom was.
Was that before or after the cash register?
That was, it's kind of at the same time. It's like at a, it's like a giant area where there's like self-checkouts.
Are these self-checkouts?
Yes.
Is there a long looping line to the self-checkout?
Correct.
Okay. Did he still have the cart with him?
He did. So he left the cart actually by me, and then he went to the restroom.
What did he do? Did he come out of the restroom?
He did.
What did he do upon coming out of the restroom?
He grabbed a cart and proceeded towards the opposite side of the store, which would be the grocery side.
Okay. What did he do upon getting to the grocery side?
He pushed the cart out, exiting the store without offering anything.
Did you stop him at that point?
Yeah.
Did he say anything to you upon stopping him?
He said, I can't recall exactly what he said.
Or he did say something?
He did.
Okay. And what did he do upon you confronting him?
He walked past me and then went out the doors going to on the grocery side in the parking lot.
Did he abandon his cart, or did he try to take his cart with him?
He abandoned it.
Upon scanning these items, was a receipt produced?
This is the breaking point. The judge has allowed argument, interruptions, repeated complaints about discovery, and even extended explanations about procedure. But once the defendant starts challenging whether the court itself is legitimate, and whether attorneys are licensed to practice law, the line is crossed. That is where patience ends. Judges will tolerate disagreement, but they will not allow the courtroom to turn into a platform for arguments that have nothing to do with the charged offense. You can hear the final warning in the judge's voice: stop now or be removed. At this stage, the issue is no longer retail fraud alone, it is courtroom control, and the judge is making it clear who holds it.
What is that?
It's a receipt from where?
And did it fairly accurately pick the items you scanned from the cart?
Yes.
Has that receipt been edited in any way to your knowledge?
Well, no.
You will go to that People's Exhibit 1.
Show it to the. Okay, sir, that is People's Proposed Exhibit 1. Hello? Well, he's offering it. Is there an objection? Okay, no objection heard, admitted.
Sir, does monitor camera,
We did.
and were those cameras working and operational on that day?
They were.
And did, upon him leaving the store, did you contact law enforcement? Did law enforcement come to your location?
They called him like in the they went towards 12 Mile, made a right. I'm sorry, I don't know if it's east or west, but made a right, and they caught him right there. And then they came.
So, okay, so to answer my question, law enforcement did come to your location?
Yes.
Upon them coming to your location, did you show them video for this then?
Yes.
Previously to you taking the stand, did I show you what's on the splash drive?
Yes.
Is what's on the splash drive the videos from Myra that day?
Yes.
People will move to next People's Proposed Exhibit 2.
Any objection?
People's Proposed Exhibit 2 is the camera footage from Myra, correct?
Yes.
And that's the same footage we turned over to the police? Yes. People will move to next People's.
I'll object to the fact, guys, I haven't had a chance to go over, take previous to the examination. You know what I'm saying? I'd like to state for the record that being able to go over there would be part of our discovery. And since the prosecutor said, I guess in part of his word, I guess he's making precedence that you don't have to give.
But why don't we do this, sir? Let's play the video without admitting it so you can watch it. Then if you have an objection, you can lodge your objection at that time. All right, sir. Head back to your seat. So that's the video that he seeks to admit. Do you have an objection?
Yeah.
What is that?
A complete video of the incident that happened. Because at this junction right there, I was going to the bathroom and I did not go past.
Okay, but sir, that's an argument. You can make an argument later. The question is this the video that purportedly was taken by Meyer cameras and turned in by this witness to the prosecutor's office? He said that's what it is. Now you can question the validity of it, the length of it, how long it was, but doesn't affect the admissibility of it. So, okay.
I don't have access to go over the ground and take myself, yeah, because I haven't been allowed my copy of the tape order.
Well, it's not your time to ask the questions yet. You get a chance to.
I don't have a copy of the tape to go over.
So you don't need it. You watched it.
Well, I'm watching and I'm trying to verify what's going on.
Okay, but you're not doing it right. You have to wait till he asks the witness questions, and then you'll get a chance to ask the witness questions too.
Sir, you see the person in the middle of that video that looks like it's got a white stripe at the bottom of his leg?
Yes, sir.
Okay. Is that the person you identified as the defendant?
Yes, sir.
Okay. That card he appears to be holding it in his hand. Is that the card you took the items out and then scanned to create that receipt, which was People's Exhibit 1?
Yes, sir.
Okay. People are good fun.
Where's the car?
It's right there at the entrance by that lady in the blue shirt and pants. She's holding it.
How did we get there?
You were,
I take it.
sir, if you watch the video, it shows you, he identified you pushing the cart, and when he got to that part, they stopped you
Okay.
and took the cart.
Now they took the car, but there was an individual. It was a young black male.
Okay, sir.
It was, hold on, y'all.
But you're not testifying.
It was a young. I'm not testifying.
Yes, you are. You're trying to tell us your story, and this
I'm
is
trying
not.
to tell you that the tape. This is not the full tape.
Okay, this is not the time.
This is not the full tape.
Okay, sir.
This is not the full tape. How can you show half of the tape and then the sequence instead of showing the whole tape? From the times that I left the black part with the where I was paying for the tape and walked in there, there's a whole step was missing.
In the end, the judge ruled that probable cause had been established for first-degree retail fraud. The prosecution presented testimony from store asset protection, a receipt showing the value of the merchandise, and surveillance footage supporting their claim that the defendant left the store without paying. The defendant insisted the footage was incomplete, argued that discovery had been delayed, and maintained that key context proving his intent had been ignored. But at this stage, the court was not deciding guilt or innocence. It was only deciding whether enough evidence existed for the case to proceed to trial, and the judge found that it did. What made this hearing unforgettable wasn't just the retail fraud charge, it was the constant clash between courtroom procedure and the defendant's refusal to accept how the system was moving around him. Representation disputes, discovery battles, and challenges to the court's authority turned a standard hearing into a dramatic legal standoff. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.